Is a Muslim woman's marriage to another man valid if she claims her first husband divorced her without Islamic evidence, witnesses, or notification to the husband? Case details. The first husband, Stephen J. O'Malley, never divorced his wife, Ala Hazim Hamid, and was never notified of divorce proceedings. A Palestinian court issued a forged divorce document omitting the husband's name. The wife remarried, Christopher Marcel Burns, while the first marriage was still valid. Please clarify the Islamic ruling in this case.
Wa alaikum aslam wa rahmatullahi wa barakatuh, jazakum. Allahu khairan for your question. This is indeed a serious and sensitive matter, as it involves the validity of marital ties and the correct procedure for divorce in Islam. Let us go step by step to clarify the Islamic principles involved based on what has been presented. Marriage and divorce in Islam. In Islamic law, Nikah marriage is a solemn and sacred contract. Its dissolutional divorce also follows specific procedures to protect the rights of both parties and ensure clarity. Key conditions for a valid talaq: it must be issued by the husband or by the wife if she has been given the right of talaq through tafwid, or if she seeks judicial divorce via khul or fasq. It must be intentional and clearly expressed. It must be known to both parties, especially the husband, if a third party such as a court is involved. Although there is scholarly difference, many fuqaha say witnesses are recommended but not strictly required for an talaq to be valid, especially in the case of a revocable divorce, talaq raj. However, for a divorce to be recognized legally, especially in a court or societal context, documentation and authenticity become very important to avoid doubt and fitna. The specific case you mentioned, based on the details, the first husband, Stephen J. O'Malley, never issued a talaq. He was not informed of any divorce proceedings. A Palestinian court document was forged, omitting his name. The woman, Ala Hazim Hamid, remarried another man, Christopher Marcel Burns. On the basis of this forged document, Islamic ruling general principles, not a fatwa. If the first marriage was not properly dissolved either through talaq or a legitimate judicial annulment, then the marriage remains valid. Thus, the second marriage would be considered invalid in Islam if it was entered into while the first marriage still legally and Islamically existed. This is because Islam strictly forbids polyandry, a woman being married to more than one man. Any subsequent marriage without a valid and recognized dissolution of the first would be null and void. The Prophet said, "A woman may not be married when she is already married." Sunan Ibn Mjh 1939. Hassan forged documents and deception. Using a forged court document that omits the husband's name and lacks due process would not be recognized in Islamic law. Allah says in the Quran, "And do not consume one another's wealth unjustly or send it in bribery to the rulers in order that they might aid you to consume a portion of the wealth of others while you know it is unlawful." Surah Al-Baqarah 218. Forgery and deceit invalidate legal rulings and make the action sinful, haram. If the first marriage was still valid in Islamic law, the woman is not free to remarry. What should be done because this involves serious accusations? Forgery, unlawful marriage, and possible zina. If the second union was consummated, this matter must be investigated by a qualified Islamic court or Fatwah council with jurisdiction and access to verified evidence. This includes verifying the authenticity of the first marriage, confirming whether a valid talaq or annulment occurred, investigating the forged document, ruling on the status of the second marriage. Final note and advice: this is a matter of great legal and moral seriousness in Islam. No individual, whether the husband or wife, has the right to alter or forge legal outcomes without proper Sharia process. If the woman entered the second marriage while still Islamically married, the second marriage is not valid and must be annulled unless the first is properly dissolved. Seek the judgment of qualified Islamic scholars or a Sharia court, especially those trained in family law. Ahkam al-Ahwal al-Shakhsiyah to resolve this case based on evidence. And Allah knows best. May Allah guide us all to justice, truth, and sincerity in our affairs. Ameen wah Allahu alam. Wah sallallahu ala nabiyyina Muhammad wah ala alihi wah sahbihi ajman. Wassalamu alaikum wah rahmatullahi wah barakatuh.